This is the plaintiff, Nelson Montalvo. He says he hired the defendant to go after a tenant of his that owed him money. The guy recovered the money from him, but didn't give him the correct amount he was supposed to. That's right, the defendant was actually taking money for himself that was rightfully his, and that's so not right. Bottom line, the sneaky guy owes him exactly $451.50, and that's precisely what he's suing for today. This is the defendant, Gil Kreider. He says he's a bill collector of sorts, and any money he recovers for a client, he gets to keep 30%. He tracked the plaintiff's tenant down, found him hiding out in Florida, and started collecting money from him for back rent he owed the plaintiff. He simply took out his 30% commission, sent the plaintiff the rest, and has no idea what the man's beef is and why he's being dragged into court today. He's accused of keeping too much for himself.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case on the docket. The plaintiff hired the defendant to hunt down a tenant who owed him money, and the defendant didn't fork over all the cash. But the defendant says it's standard. He gets 30%. It's the case of 30 is the new 100.
Thank you, Douglas. Nelson Montalvo?
Yes.
You are suing Gil Kreider, doing business as Bloomingdale Road Judgment Recovery, for $451.50 that you say is still owed to you on a contract you had with him to collect a otherwise uncollectible judgment, or a theretofore uncollected judgment. All right, let's take some steps back. You had a judgment against a tenant who left many months ago.
That's correct.
And you were a landlord.
That's correct.
And you got a judgment for $3,895.
That's correct.
The guy wasn't paying.
No, he didn't.
Right. So how do you hear about the defendant?
I went to court first, and I received a judgment. The judge ruled on my favor. I contacted the marshal's office on February of 2011, and the marshal, I went to see him if he could help me out, with the assets, and he couldn't help me out with no assets or nothing like that. So he recommended Mr. Gill, and
what do you do for a living?
Collect judgments.
Okay, that's all you do?
That's all I do.
How did you get into this business? You're the enforcer?
I had a portfolio of truck leases that I was managing, and when freight rates collapsed in 2008, I had to repossess trucks all over the country.
You got a taste for it?
Learn to love it.
I used to be a repo man.
I would have hired you.
For real. I was 18 years old. They would only let me do it over the phone because I had this very deep, menacing voice, and I'd get people to pay their bills. And then I only repoed one car, but I would a bill collector over the phone for a bank for the loans. That was my first job. There's a little trivia for you. All right. Now, there's a way that you can do this. I mean, the law has a system set up. There's a statute that covers that you can have even if you don't have a lawyer, you can have a lawyer investigate what assets a person has, or you can have a hearing where you get to ask the person those questions in front of the judge. I mean, there's things you could do to help yourself, but it's costly, time consuming, and so this doesn't seem like a bad way to go. You take what percent?
In this case, it was 30%.
And what's the going rate?
Sometimes I get 45%. 33% is pretty typical.
Okay, so it's 30%, 70%. You don't have to worry about anything. He only gets paid if he's actually collecting it, so it seems like kind of a good, effortless way to go.
That's
so
right.
You make that decision, you go with him, and you find the guy, or was easily found, but you persuade the person to go on a payment plan.
Yeah, I found him in Florida. And he was willing to pay it off. Well, I had his bank account also, but there wasn't much in it.
Did you freeze it? Did you have to freeze? Did you?
Yes, but there wasn't enough. It was below the statutory amount, so I really couldn't get anything from the bank account. But the next step was to find out where he worked by what deposits went into the bank. So
you explained all that to him. You explained to him, I'm going to garnish your wages, I'm going to do this, I'm going to do that. There's an easy way and a hard way.
Judgment of Florida, which is very expensive to do, which would get added on to the
So he agrees to pay the whole judgment?
He agreed to pay it out over time.
So he pays it to you.
Correct.
And then you send him 70% every month and keep 30. That goes on for how many months?
I think it was over a year, maybe a year and a half.
And then so approaching the end of the year and a half, what happens?
Then I said to Mr. Montalvo that we're coming to the end, and I sent him, in the envelope with the check, I sent him a satisfaction of judgment. So that
Did you still have payments to?
There were still payments to be deposited and to be paid to him, but I said, I'll hold the satisfaction until all the payments clear, but I just want to have it so that we can close this out.
And your reaction to that was,
How could that happen?
how am I going to sign a document that says you paid me when you haven't paid me yet?
That's exactly.
Okay, and then?
So then Mr. Montalvo actually called me and he said his lawyer advised him not to do it. So I said, well, if you want, just fill out the satisfaction of judgment and send it to your lawyer. Let him hold it until all the payments are done, and that way
But
it'll
why
be
is this
closed out.
happening? Why are you so afraid?
It's not that I'm afraid, but I collected a $20,000 judgment upstate New York where I sent the client the money, and then he lives in Canada and he says there's some large expense to actually filling out a satisfaction of judgment in Canada, and so he refused to do it. So now the attorney for that judgment debtor is calling me, asking me about this satisfaction of judgment. I can't do anything about it. So I figured this way I close everything out.
Let me see the satisfaction of judgment that you wanted him to sign. So it's not really for your benefit, it's for the benefit of the debtor who's paying you, because that's what they're going to ask for when they finish
when they're
paying.
done. Yeah, exactly.
Okay, let me see it.
This was the version I sent to Mr. Montalvo. This would be one that would be done currently if we come to that.
Now, his lawyer had nothing to do with you, though, right?
Never.
But his lawyer's going to charge him for escrowing
That's
something and
exactly
everything else. So it's an expense for him. Why don't you guys? I don't understand. I don't understand. So what you don't? But I don't understand either of you. I understand him because if somebody said to me, "Here, sign this that it's all paid," and it's not all paid, I ain't going to sign it. Very simple. ABC. I'm not going to sign it. And I understand why you're gonna want one. But why don't you just wait till you pay it to get one? I don't understand.
Because after Mr. Montalvo is all paid off, there's no incentive for him to sign.
What is, are you kidding me? Why don't you both just, here's the last payment.
That's right.
Here's
Well,
why don't you do that? Why am I here? You're killing me.
I'm happy to do it.
Yeah, but you're wasting my time and it's my birthday.
Thank you very much.
I'm shocked.
Happy birthday, Judge.
You're my last case.
Thank you very much.
I'm here because are you kidding me? But it's not one payment. It's 3 payments that you haven't paid him.
Right. They're small payments. I wanted some sort of incentive.
Okay, but I can understand how you can have a right to the last payment. Look, I'm not going to give you that last payment. But you can't get a guy to sign a satisfaction of judgment when you're 3 months ahead of schedule.
I have no reason to satisfy the judgment ahead of time. I'm just
pocketing
acting
the
as
money and then telling him you don't get any money. You claim the judgment was
right.
satisfied. You must be mistaken. I had a balloon payment. Of course, you could do a million things. But it just doesn't even make sense. You guys don't make sense to me. He doesn't want to hire a lawyer to do something because you're uncomfortable and queasy about something. It's just done every day. The satisfaction is here. The check is here. And you each hit it. Did you bring a check?
I did.
Did you bring a check
I
for
did.
the remaining money?
I did.
Does it amount to $451?
I'll make it out.
And 50 cents? Do me a favor.
Yeah.
By the way, hand this to him. Do me a favor. Sign that.
Thank you.
So is 30% off the top excuse me. Exorbitant, or is it reasonable?
It's too high. It's too high of a collection.
What is then?
15 maybe.
Really? What do you think?
10%.
10%?
Realtors make 6%.
Yeah, but if 30%?
Too high. Don't know what the actual amount should be, but 30% way too high.
God, I'd hate to tell you what lawyers charge. Oh, going inside the courtroom.
Gentlemen, walk to each other, stop in the middle, and hand it to each other.
Make an exchange.
There you go.
Back up.
There you go.
Back to the
Shake
spot.
hands, gentlemen.
Shake hands.
There you go. Case closed. Adios.
Well, here comes the defendant, and that was easy.
It was easy.
Why do we have to come here to do that?
I guess I wasn't willing to go to Staten Island.
Oh. All right. Head right down there, okay? And sign your way out. All right, come on in here. That was easy.
Very easy. How could I sign something in satisfaction of judgment if he hasn't paid me the money yet?
Right. But well, you have your money and he has his document. Everything's cool.
Correct, and
How come you couldn't get him to do that without coming in here?
Well, I did. I called him a couple of times. He won't budge. So this is the way I had to do it. I had to go to court, small court claims, and then I came over here.
All right. So take it away, Harvey.
You know, it's so funny. Sometimes people lock themselves into a position to the point where there's no way they can actually sit down and settle this thing, yet it would be so easy to do. This is a good example that there are ways of avoiding court. Nobody wins when you have to go to court. If you can settle it reasonably, almost always it's the best course of action.